नहीं है सर,
खबर किया है?
अदर साइड है ही नहीं, ऑब्वियसली
अपीयर कर रहा है नाम।
वो स्टेट की तरफ से माय लॉर्ड है, वो उनको इन्फॉर्म कर देंगे।
Accordingly, the second appeal is dismissed as not pressed. Communicate करिए इसको।
लॉर्डशिप आइटम नंबर 7,
साइन करना होगा आपको।
आइटम नंबर 7 डेली का विड्रॉ करना है, जो 25 लाख तक फाइल होगा, नया आया है, सूट वैल्यू कम है, तो इसलिए लिबर्टी दे दी है, नीचे कोर्ट में वहाँ जाकर परसू करेंगे। अभी नया जो है ये
ऑब्जेक्शन आया है, ऑफिस ऑब्जेक्शन है।
ऑफिस ऑब्जेक्शन नहीं है, लेकिन अभी जो आया है जो 25 लाख तक फाइल होगा।
ऐसे नहीं होगा
जी,
ऐसे नहीं होगा। अभी जो आया है कब से इफेक्टिव है, कब से इफेक्टिव नहीं है। पुराने ऑर्डर्स में तो हुए हैं कि मैटर रेमिट बैक हुआ है, लेकिन हम ऐसे नहीं करेंगे।
जैसा आदेश हो चुका, लेकिन जो हम जानकारी दिए 25 लाख तक अभी जो लेटेस्ट आया
आई डू नॉट नो, आपके कहने से तो हमने ना, तो मेरे पास लेटेस्ट की कोई कॉपी है ना, उसका इफेक्टिवनेस का डेट हमको मालूम है, कुछ भी नहीं मालूम है। आप लेके आइए,
ठीक है, समय दे दिया जाएगा तो
डिफेक्ट रिमूवल के लिए हम समय दे देंगे।
From the supplementary list under heading for orders we decide item 1 FA 320/2023.
Yes, there are its defective petition.
Yes,
To remove the defects. How much time do you need?
Lord, I will filing Lord with respect to defect number 5, Lord. There is one defect that 2A has not been included as a parting, Lord. And in terms of Jharkhand High Court.
We do not know. Either you file IA
Yes, Lord, I will
or
file that.
whatever you remove the defects.
I will file 4 weeks time.
देखिए FA number 320 of 2023. The learned counsel for the appellant prays for and is granted time till 4th of February 2025 either to remove the surviving defects or to file appropriate interlocutory application. Preemptory. If this order is complied, pose this case on 11th of February in the supplementary list.
Bishop, I am appealing for respondent number 10.
Respondent number
10.
10. Counsel for the respondent number 10 is present. You give your appearance.
Yes.
Under heading for admission item 2 WPC 3265 of 2023.
Yes.
To the last order,
Why have you not filed your counter?
State has filed.
State is filed.
We have filed on 28th September.
अभी लेके आए हैं ना? Okay, what is your stand? What is your stand in the counter-affidavit?
So we have taken a stand that these land which was acquired of the village area was not acquired by the 2013 Act, Lordship. It was acquired with respect to the prior acquisition Act, Lordship.
Under this Land Acquisition Act, National Highway.
Lordship, it is not acquired under Land Acquisition Act of 2013, Lordship. Lordship, acquired under 1956 Act से इसको acquired किया गया.
National Highway Authority.
Lordship.
Which is not the relief as prayed for in this writ petition. Which is not the relief as prayed for in this
Lordship,
writ
with respect to that also, Lordship, under section 105 of the NH Act, Lordship, we have put the subsequent
105. Where have you mentioned?
para 10 year Lordship. The family will committed to that.
What about Union of India?
Should they have
Whom are you representing?
Government, Honorable Governor.
What do you have to say?
Last date related as a party, therefore that.
therefore means what? There is a direction of the Honorable Supreme Court. आप कैसे इस तरह से करते हैं? आपको कॉपी नहीं मिला क्या? तो you were waiting for the next day to pray for time. Yes.
No, Lordship,
Then?
I only pray for further preview and because we implement as a party on last day.
That's right. The records were made available to you. The order was made available to you. Why have you been sitting over it? Only for the next day to pray for time?
No, Lordship, we have already sent the copy to Honorable Governor.
Where is Union of India? Have you served the copy on the other respondents? Yes,
Yes, Your
respondent.
Yes.
Respondent, have you served the copy on other respondents
The-
of your counter affidavit?
Shall have to check with the clerk.
What do you have to check with the clerk? You are not aware that you are supposed to serve copies on all the respondents.
Lordship, I am aware of that.
Then?
Without that, it should not even be accepted.
You have not served it. The receipt does not show that you have served it. You served them during the course of the day. You have received the counter affidavit.
Yes, Your Lordship.
The accusation is not under 2013 Act. The matter ends.
Your Lordship, I will come a rejoinder on this, Your Lordship.
We will not allow any amendment.
No amendment, Your Lordship.
You file a rejoinder, whatever. Because they have annexed a copy of the notification and they say that the accusation is not under 2013 Act. The matter ends.
But the annexure 1, they have annexure A, which they have annexed. It is about the 4th schedule, Your Lordship.
We do not know.
Lordship,
They have said that the acquisition of the land involved in this case is not under the Act of 2013.
Yes, Your Lordship, I have seen I have read the contract, I have gone through the contract, Your Lordship.
Yes.
But it is required the rejoinder is to be required. In this case.
You find
There is
how
no
1 week should be
amendment,
sufficient.
amendment anything.
1 week should be sufficient.
Yes, Your Lordship.
Learned counsel for the parties are present. A counter affidavit has been filed on behalf of respondent number 1 to 5, stating that the property involved in this case has not been acquired under the provisions of the
NHA.
Land Acquisition Act, Land Acquisition, Rehabilitation and Resettlement Act of 2013. Rather, the same has been acquired under National Highway Act 1956. It has also been mentioned that that in view of section 105 of the Aforesaid Act of 2013, in view of section 105 of the Aforesaid Act of 2013, the Act of 2013 shall not apply to acquisition of land under National Highway Act. Counsel for the state is directed to serve 2 copies of the counter affidavit upon the learned counsel appearing on behalf of the Honorable Governor and also in the office of learned ASGL. Counsel for the petitioner prays for and is granted 1 week time to file a rejoinder to the counter affidavit. it is observed that if the averments made in the counter-affidavit is found to be correct and that the acquisition has been done under National Highway Act 1956 and not under the Act of 2013, then the relief prayed for in this writ petition seeking a declaration that the Land Acquisition Act 2013 is not applicable to scheduled area may not be granted to the petitioners as they may not have any cause of action to seek such declaration from this court.
Lordship, one thing I have,
Cause of action के बिना कोई declaration नहीं होता.
one thing I would like to.
आपको जो मर्जी हो आप करें, इसीलिए लिखा भी है.
ठीक है.
Pose this case on 16th of January in the supplementary cause list. The rejoinder to the counter affidavit be filed by 15th of January after serving copies on all the respondents.
Under heading for hearing, under Order 41, Rule 11 of CPC, Item 3, Asset 10 of 2017.
Yes. What do you have to say?
Item 3.
आप ही का केस कौन है? बताइए.
Supplementary.
Partition should be
कल सुन लिया आपका. अब आप प्रोसीड करिए फर्दर.
सबसे पहले मैं रिलायंस के जजमेंट के लॉस सीधे वो 8 years 45 days loss on the section 14 consider the petition of section 14 loss and second judgment here also 2024 loss.
You did not file your petition under section 14. You filed your petition under section 5 of the law.
Lordship, but your lordship due to wrong advice of the
Wrong advice तो आप लोग का काउंसिल का चलते रहता है. काउंसिल को सू कर देना चाहिए for wrong advice.
wrong advice because of the
Repeated wrong advice का क्या ही कर सकते हैं? Litigant has to suffer
lordship.
on account of wrong advice given by the counsel. We can't do anything about it.
wrong forum.
Wrong forum, wrong advice. आपको जितना wrong आप लोग करते हैं, वो सारे wrong litigant has to suffer because of that.
Lordship due to bona fide.
It's not bona fide. ऐसा bona fide हम लोग counsel को attribute नहीं कर सकते. All the advocates are learned advocates, so they have to justify that they are learned advocates.
Because of lordship.
इससे कोई मतलब नहीं है हम लोग को. लाइए दिखाइए कौन सा जजमेंट है आपका. कौन सा पैराग्राफ?
Lordship. मेरे lordship.
पैराग्राफ
Para
बताइए.
31 year lordship.
31 पढ़िए.
Lordship. In the view of the matter, it appears to me that the principal laid down in the above two decision against the filed event today on the point of the controversy in the start case. As a matter of fact, the principal laid down the reported decision of the
ये क्या है? कोई प्रिंसिपल ऑफ लॉ है?
lordship. इसमें lordship
When you are citing a judgment, you will cite the principle of law decided.
three issue has been framed, your lordship. In this point, your lordship. And third is regarding the limitation point of view.
There is nothing has been
Because of
laid
your-
down. It is based on the facts of a particular case.
Lordship, in this case, your Lordship, wrong forum, they should have been filed, Lordship. And then they have to, on the delay on the ground of the 8 years, 45 days, Lordship.
We don't bother about it. There is no such principle of law as such decided in this judgment passed by Karnataka High Court. Correct?
May I read, Lordship?
Show me the principle of law which has been decided, we will consider it. If a judgment is based on certain facts, we cannot do anything about it. That is not binding on us.
See, in this, I have, in this, Superior Lordship, 3 points is framed by the Honorable Court, Lordship.
Which were the 3 points? Which is para 22, right?
Lordship. Having heard both the sides, and the question that arises from my consideration are either following: whether the Appellate Society Appellate was prosecuting the earlier civil proceeding. Firstly, they are raising the dispute before the cooperative court, secondly, appeal before the CAT, thirdly, before this court, in a writ petition, and lastly, once again before the cooperative court on remand in good faith.
कौन सा issue है?
Issue number 3 was whether the Appellate Society made out a case of the condonation of delay of the 8 years 45 days in restoring the second suit over the city civil judges. And this issue has been
Issue number 1 का पहले decision दिखा.
issue number 1 Your Lordship.
What is the decision?
23 Your Lordship. Now I proceed to decide the here below, and they have 3 points in its order. Regarding the point number 1, as could be made out of the record, it is clear that the Appellate Society had at the first instance raised a dispute before the joint registrar of the Cooperative Society, Bangalore, for declaration that the allotment of the suit scheduled site number 1 in favor of the responding hearing was illegal, also for declaration that pursuant the sale deed registered on 2nd January 1976 in respect of the site of the name of the respondent was null and void on the station of the said dispute. The landed joint registrar of the Cooperative Society Bangalore had referred a dispute for disposal to the deputy registrar of Cooperative Society Bangalore in case of the JRB MIS to manage the affairs of the Appellate Society. On the issue of the notice to the respondent society on hearing the dispute passed in considered order on 15th July 1978 in favor of the Cooperative Society.
आप क्या पूरा judgment पढ़ना चाहते हैं?
Lordship,
Issue number 1 का finding बताइएगा.
Issue number 1 का finding, Lordship. The last paragraph 25, Lordship. If the entire history of the above litigation between the parties reckoned and seen in its proper perspective, in my consideration, it can be said that the proceeding at every stage were prosecuted by the Appellate Society with due care and diligence.
Yes, ये due care and diligence का आपको कहाँ से finding हम देंगे ये बताइए. There is a finding of due care and diligence in terms of section 14. That is the requirement of section 14. There is a finding in this case that the party was prosecuting his case with due care and diligence. आप दिखाइए अपना due care and diligence. Show it to us. नहीं है ना? चलिए next judgment बताइए. Yes.
May I read the memo of petition, Lordship, and before the Appellate Court, Lordship.
मेमो ऑफ पिटिशन से आप हमको ये बताइए. नेक्स्ट जजमेंट कंप्लीट करिए. देयर इज वन जजमेंट ऑफ सुप्रीम कोर्ट यू आर साइटिंग.
Lordship,
बताइए.
regarding section 14.
हाँ. Para 25 पढ़िए, section 14. Para 27 पढ़िए.
Para 25 years. The relevant portion of the section 14 of the limitation is exact as under the reference. Section 14 exclusion of the time the person is bona fide in court without limitation. In the computing the period of limitation for any application, the time during which the applicant has been proceeding with the due diligence and another civil proceeding, whether in the court of the first instance of the appeal or division against the same party for the same shall be excluded. Here such proceeding is prosecuted in good faith in a court which from the defect of the user or other cause like the nature and unable to entertain it. 20 accepted that the provision section 14 of the limitation has find place in the limitation act applicable to the state of the Jammu Kashmir which has not been contested by the respondent. On the perusal of section 14 subclause 2 of the limitation act which is also applicable to the state of Jammu Kashmir, it is evident that the carves out in a section excluding a period of limitation when the proceedings are being pursued with a due diligence and good for the record which from the defect of the resolution or other course like nature is unable to entertain it. The first objection made by the defendant is that the plea of the exclusion of the limitation has not been raised before the court below and cannot be raised in the first instance before the peaceful. We do not find merit in the submission manner. High Court in the paragraph 9 has category as regarded.
That's right. अब बताइए, आपका ड्यू डिलिजेंस दिखाइए. ड्यू केयर एंड डिलिजेंस. ठीक है.
Memo before the first appeal.
कहाँ है आपका ड्यू केयर एंड डिलिजेंस? Not even a word about it.
Usually one percent I set it loss.
ठीक है, आपका सारा जजमेंट देख.
Illahabad High Court paragraph 14. Paragraph 14. The only question therefore that remains is as to whether delay is sufficiently explained as we point out earlier that the Jharkhand corporation was not getting at all as it is done all within its power before the expiry of the period. So the delay, if at all, has been caused on account of the some mistake by the council or in the office, the mistake is not attributed to the party and can be attributed to the someone which has been handling its affair on its behalf of the appellant cannot be made to suffer on that being guilty at any stage for any lapse of the legality of its person.
The learned counsel for the appellant.
first appeal.
Yes. In furtherance to the arguments advanced yesterday, has referred to the judgment passed by Honorable Karnataka High Court, reported in 1997 SCC Online Karnataka 190, and has submitted that the issues, altogether 3 issues, were framed by the Appellate Court under first appeal, and the first Appellate Court, which was the Honorable Karnataka High Court, had condoned the delay of 8 years 45 days in resorting to the second suit, had condoned the delay of 8 years 45 days. He submits that delay was condoned by referring to section 14 of the Limitation Act. He has further relied upon the judgment passed by Honorable Allahabad High Court, reported in AIR 1991 ALL 317, paragraph 14, to submit that if the mistake is committed by the counsel, then the litigant cannot be made to suffer. In the said case, the case could not be filed on account of the mistake of the counsel. Within the period of limitation. There was a delay of around 2 months. The learned counsel for the appellant has also relied upon the judgment passed by Honorable Supreme Court in civil appeal arising out of SLP civil number 17665 of 2018, within bracket Purni Devi and other versus Baburam and another, decided on 2nd of April 2024, and has submitted that in the said case, the provisions of section 14 of the Limitation Act has been considered, and by referring to the earlier judgment has been considered and delay has been considered. He has submitted that in the said judgment, the order of the High Court to rejecting the plea for exclusion of time in terms of section 14 was considered, and the finding of the High Court was set aside, and the execution application filed by the plaintiff was restored. The Learned Counsel has reiterated that the appellant has been pursuing his remedy before other forums under wrong advice of the counsel. And therefore, section 14 of the Limitation Act is applicable, and the period during which the appellant had pursued the matter before other forums is required to be excluded. And this aspect of the matter has not been considered by the first applicant. And therefore, a question of law arises in the present case. A substantial question of law arises in the present case. He submits that the appeal be admitted on the question of law arising out of applicability of section 14 of the Limitation Act. After hearing the Learned Counsel appearing on behalf of the appellants, appellant एक है कितने हैं? Appellants. And after going through the impugned judgment, this court finds that it is not in dispute that the matter arises out of partition suit number 15 of 1988. Which was filed by the father of the appellants, the 15 of 1988, and the suit was decided in which written statement was also filed and contested. But the suit was decided by judgment and decree dated 29/9/2004 against the said judgment. No appeal was filed, and a civil miscellaneous petition number 1 of 2006 was filed. Under Order 9, Rule 7, 13 read with Section 151 of CPC. On behalf of the, you were the defendant in the suit?
Yes.
On behalf of the defendant, which was dismissed by order dated 22/9/2007. The Appellate court has recorded that it was apparent that after the decision of the partition suit, the defendants were sleeping for more than 1 year and they did not challenge it in any proceeding till filing of miscellaneous case number 1 of 2006. Further, after dismissal of the miscellaneous case number 1 of 2006 on 22/9/2007, a miscellaneous appeal number 5 of 2007 was filed before the Court of District Judge, which was dismissed on 7/6/2010 due to non-prosecution. Thereafter, the petition for restoration of miscellaneous case number, thereafter, another miscellaneous case number 3 of 2010 was filed for restoration of miscellaneous appeal number 5 of 2007, and the same miscellaneous case was also dismissed on 21/1/2016. And only thereafter the appeal, being civil appeal number 10 of 2016, was filed against the judgment and decree dated 29/9/2004 with a delay, with a combination of delay, with a delay of 4137 days in filing the appeal, which was dismissed by the interim judgment dated 4/10/2016. The learned appellate court, after considering the entire gamut of affairs and the history of the litigation, has recorded a finding that the conduct of the appellant was not fair, rather he was only interested in prolonging the proceedings, and there was lack of bona fide on the part of the appellants. During the course of hearing, the learned counsel for the appellants has not been able to show any material to satisfy this court in connection with section 14(2) of the Limitation Act, which requires that in order to get the benefit of section 14, the party has to demonstrate that he was pursuing his matter bona fidely and diligently and in good faith before another forum. This court finds that the requirement of section 14(2) of the Limitation Act is not at all satisfied in the present case. Rather, the initial petition was filed after expiry of the period of limitation as recorded by the learned court, and further one of the petition was also dismissed for non-prosecution. the argument of the learned counsel for the appellant that the litigant should not suffer on account of fault on the part of the counsel is not acceptable to this court under the facts and circumstances of this case. In view of the fact that it was for the litigant to be vigilant and also to take care of the proceedings, and there is no whisper from the side of the and also to take care of the proceedings, and no foundational fact has been brought to the notice of this court regarding showing of due diligence on the part of the applicants. The findings recorded by the learned appellate court in refusing to condone the delay and dismissing the first appeal are well-reasoned findings based on appreciation of materials on record. In such circumstances, no substantial question of law, much less any substantial question of law, arises for consideration by this court in this second appeal. So far as the judgment passed by Honorable Karnataka High Court is concerned, in the said case, while deciding issue number 1, the Honorable Karnataka High Court has clearly recorded that the proceeding at every stage was prosecuted by the appellant society with due care and diligence, and they were serious throughout to take care that it is taken to a logical end. And this was the finding while deciding issue number 1, and consequently while deciding issue number 3, the delay of 8 years and odd was condoned by referring to section 5 and section 14 of the Limitation Act. In absence of any due diligence from the side of the appellants, as mentioned above, the state judgment cited passed by the Honorable Karnataka High Court does not apply to the facts and circumstances of this case. So far as the judgment passed by Honorable Supreme Court in the case of Purni Devi is concerned, in the state judgment also, the Honorable Supreme Court, in the state judgment, the Honorable Supreme Court has considered the basic requirements of attracting section 14 of the Limitation Act, and one of the conditions are that the prior proceeding has been prosecuted with due diligence and in good faith. And by considering the phrases due diligence and in good faith, the Honorable Supreme Court has referred to the earlier judgment passed, wherein it was held that these phrases only mean that the party who invokes section 14 should not be guilty of negligence, lapse, or inaction. Further, there should be no pretended mistake intentionally made with a view to delaying the proceedings or harass the opposite party. This court finds that the factual matrix of the present case clearly indicates that there was complete lack of due diligence and good faith. Due diligence on the part of the appellant, and this court is of the considered view that the learned First Appellate Court has rightly refused to condone the delay by referring to condone the delay, and the said delay was not condonable even by referring to section 14 of the Limitation Act. The principles of law as laid down by the Honorable Supreme Court in the case of Pune Devi cannot be disputed, but those principles do not apply to the facts of the present case in order to attract section 14 of the Limitation Act. Consequently, there being no question of law, having no substantial question of law arises in the present case for consideration. Accordingly, the second appeal is hereby dismissed. दो judgments हम इसमें साइड करेंगे second appeal का. So, चलो. ये देखिए.
Item 4, second appeal, level 37/18.
आपका प्लेंट में सिर्फ डिग्री 9 डेसिमल का हुआ है, 14 डेसिमल का नहीं. करेक्ट?
5 डेसिमल के लिए हुआ है.
आपका जो प्लेंट है, जो आपका सूट है, टाइटल सूट, उसमें सिर्फ 9 डेसिमल का डिग्री हुआ. देखिए, टाइटल हैज बीन डिक्लेयर्ड ओनली इन कनेक्शन विद 9 डेसिमल, 14 डेसिमल का नहीं हुआ डिक्लेरेशन. You just see title, trial court's judgment. You are there for
I've
the
got the Governor today, ma'am, with no objection of my predecessor lawyer. So kindly permitted to file this before filing.
हम डिसमिस कर रहे हैं, आपको क्या बोलना है?
कोई बात नहीं, डिस्मिस करने के लिए हम
हाँ, बैठ जाइए. अब बताइए, सेटिस्फाई होंगे तो आपसे सुनिए. यस, ट्रायल कोर्ट का जजमेंट देखिए. पढ़ी, लास्ट पैराग्राफ.
सूट फाइल हुआ था कैंसिलेशन ऑफ
सेल डीड के लिए, and for also you see it was for a decree for vacant possession of the suit property, right?
यस सर.
Right? And the declaration of title is only in connection with 9 decimal of land. पढ़िए,
यहाँ पे
ट्रायल कोर्ट का जजमेंट पढ़िए,
इसमें
लास्ट पैराग्राफ. It is not in connection with 14 decimal of land, only in connection with 9 decimal of land.
लास्ट पैराग्राफ. द्वारा बिना किसी अधिकार के उक्त विक्रय विलेख निष्पादित किया गया है, इसलिए उक्त विक्रय विलेख को रद्द किया जाता है. इसलिए वादी विवादित भूमि का आधिपत्य पाने का पुनः अधिकार है.
देखिए ना आगे, एकदम लास्ट का 4-5 पैराग्राफ, 4-5 लाइन पढ़िए.
स्थिति साक्ष्यों के साक्ष्य प्रदर्श के अवलोकन पाता हूँ कि तर्कों को सुनने के पश्चात यह घोषित किया जाता है कि खाता संख्या 54, CS प्लॉट नंबर 660, RS प्लॉट नंबर 1301, रकबा
9 decimal,
9 डेसिमल की भूमि पर
14 decimal पर डिग्री नहीं है.
प्रत्य एवं हित है.
करेक्ट?
तब तो ये
सिर्फ 9 decimal पर.
कॉन्ट्राडिक्टरी फाइंडिंग होंगे.
कॉन्ट्राडिक्टरी फाइंडिंग नहीं है. You see, judgment has to be read as a whole. ऐसा आपका एक लाइन कहीं से नहीं पढ़ सकते ना.
नहीं
और इसी जजमेंट को अपहोल्ड किया है, राइट?
तो अपीलेट कोर्ट तो ये पाया ना
और अपीलेट कोर्ट ये नहीं बोला कि 14 डिसमिल का डिग्री हो गया. नो, दैट इज नॉट द फाइंडिंग ऑफ दैट.
इसके अलावा तो
इतना से तो आपको खुश हो जाना चाहिए, सिर्फ 9 ही डिसमिल का डिग्री हुआ है.
इसके अलावा
जजमेंट में लिखते हैं. बताइए क्या पढ़ना है. Substantial question of law.
Substantial question. Suit is barred by law of limitation. As because plaintiff have prayed also for recovery of possession. When suit has been filed in prayer portion of it, plaintiff has admitted that he has dispossessed since 8/8/91. 91 से 91 नहीं बोल रहे हैं.
एडवर्स पोजीशन का क्लेम था आपका?
नहीं, हम सूट तो
नहीं किए ना.
डिसाइड हुआ ऑर्डर 8/10 में.
हाँ, ऑर्डर 8 में आपने तो रिटन स्टेटमेंट नहीं फाइल किया, तो क्या होगा? एडवर्स पोजीशन हो जाएगा. 1981 से पोजीशन में है तो
मेरे का मतलब सूट इज बार्ड बाय लॉ.
बार्ड बाय लॉ ऑफ लिमिटेशन.
ये इशू फ्रेम होना था.
नहीं, कुछ नहीं होना था. जब आपने प्ली ही नहीं लिया एडवर्स पोजीशन का, तो क्यों ही हुई ये इशू फ्रेम होना था?
Court has power to frame issue also on the point of law.
ठीक. देखिए, सेकेंड अपील नंबर 337 of 2018. Heard the learned counsel appearing on behalf of the appellant. कल इनका सबमिशन लिखा है 6/1/20. In furtherance to the arguments advanced on 6/1/2025. The learned counsel for the appellant has submitted that the suit was decreed under the provisions of Order 8 Rule 10 CPC, but the learned court has not considered the fact that the suit was barred by limitation. Inasmuch as the defendant was in possession of the property since 1981. कहाँ से लाए हैं 1981?
पेज 18 अपीलेट फॉर जजमेंट इंटरनल पेज 3 इसमें द फ्लोइंग प्लेंटिफ रेज फ्लोइंग रिलीफ इसमें डी में फॉर रिकवरी ऑफ मीन्स प्रॉफिट is 2000 rupees per month since 8/8/91 till decision of the suit.
1991. Okay. The learned counsel submits that the defendant being in possession of the property since 8/8/1991, the suit for recovery of possession was barred by the law of limitation, and the learned court did not frame any issue on the point of limitation, and has failed to consider that the defendant had perfected his title by way of adverse possession. Adverse possession?
हम टाइटल क्लेम नहीं कर रहे हैं. मेरा सिर्फ नहीं कहना है सूट इज बार्ड बाय लॉ.
You have perfected your title by adverse possession?
No.
No. खाली इतना लिखिएगा कि and accordingly the recovery of the prayer for recovery of possession was barred by limitation. The learned counsel during the course of argument, the learned counsel for the appellant was called upon to place the judgment passed by the learned trial court, wherein, and it has been found that the learned trial court has declared the right title of the plaintiff in Khata number 54, CS plot number 660, RS plot number 1301, area 9 decimal only, and has set aside the stated bearing number 7226 dated 17/8/2006, which related to sale of 5 decimal of property. After hearing the learned counsel for the appellant, this court finds that the case of the plaintiff as per his plaint was that land bearing 660 under bearing plot number 660 under Khata number 54 of Mauza Kandra described in Schedule A belonged originally to and stood in the name of Lal Chand Puri and Jaidev Puri jointly, and in the year 1925 Jaidev Puri died issueless, hence the interest devolved upon Lal Chand Puri, who died leaving behind his 2 sons, namely Ram Bhushan Goswami and Rampal Goswami. Ram Bhushan died leaving behind his only son, Rakho Hari Goswami, who was the plaintiff before the court, and Ramphal Goswami died leaving behind his 2 sons, Ravindra Goswami and Sikandar Goswami, and widow Santoshi Goswami. Who were the and Santoshi Goswami. It was alleged in the plaint that ancestral properties of the parties were mutually partitioned, and accordingly the suit land fell in the share of the plaintiff, and he came in possession and in revisional survey settlement records of right being number 162, prepared and published on 24/2/1992, it stood in the name of the plaintiff only, in which CS plot number 660 renumbered as 1301 area 9 decimal out of 14 decimal was in his possession, and out of 14 dismil, as 4 dismil was already sold by Ramphal Goswami to Bhagwati Devi, the mother of defendant number 1. And the defendant number 1, Kisan Maharaj, had confirmed the plaintiff as the absolute owner of the suit land by executing a deed of exchange dated 8/8/1991. In which the plaintiff gave 3 decimal of land of such property to defendant number 1, and defendant number 1 gave 5.5 decimal of land of plot number 659 of the same Moza to the plaintiff. It was the plaintiff had requested several times to the defendant to effect the terms and conditions of exchange, but the defendant executed a sale deed bearing 7226 dated 17/8/2006. Which was for 5 decimal of land. The plaintiff prayed for following relief. Page number 18 में Appellate Court Judgment. Before the trial court, in spite of notice, the defendants before the trial court, the defendants appeared, but they did not file any written statement, and they were debarred from filing written statement under Order 8 Rule 10 of CPC. And ultimately, the suit proceeded, and the plaintiff examined altogether 4 witnesses and exhibited certain documents. The case proceeded under Order 7 Rule 11 Rule 10, the Order 8 Rule 10 of CPC. The learned trial court took only one question for determination as to whether the plaintiff was entitled for any relief. The learned trial court considered the materials on record and held that the plaintiff was entitled for the plaintiff had right, title and interest in connection with Khata number 54, CS plot number 660 RS plot number 1301, area 9 decimal, and consequently set aside the sale deed number 7226 dated 17/8/2006, and also held that the plaintiff was entitled for recovery of possession with respect to the land involved in the sale deed.
लॉर्ड साहब केवल शेड्यूल ए लैंड के लिए राइट टाइटल इंटरेस्ट 5 डेसिमल के लिए जो जमीन सेल हुआ है उसे
Respondent. Respondent. The learned counsel for the testimony. Record I ask. The learned counsel for the appellant has submitted that the appeal was dismissed by the appellate court. But the appellate court has failed to consider that the suit was filed seeking a declaration of plaintiff's right title interest over Schedule A land, cancelling the registered sale deed number 7226 dated 17/8/2006, and the Schedule A land was only in connection with the land involved in the sale deed, and he has submitted that the court has granted relief seeking with respect to declaration of title in connection with 9 decimal of land, although the suit property for which the declaration was sought was only with respect of 5 decimal of land. The learned counsel has submitted that the courts have granted relief to the plaintiff which was beyond the relief sought for. Correct? After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on following substantial question of law: whether the learned courts were justified in granting relief to the appellant beyond 5 decimals of land which was involved in sale deed number 5226 dated 17/8/2006, in connection with which the relief was prayed for in the suit. ठीक, यही सब्सटेंशियल क्वेश्चन ऑफ लॉ पे सुनेंगे. रिकॉर्ड कॉल फॉर करते हैं, आपको सुनो. एट दिस मिस्टर नाम बताइए.
भानुगिरी, डॉक्टर भानुगिरी.
Dr. Bhanugiri, advocate, has submitted that he has received wakalatnama on behalf of the respondents. All the respondents?
Respondent, no, only one respondent. Recovery is
on behalf of
Rakaveri Goswami.
respondent number 1. आपके एक सगे भाई हैं, उनकी तरफ से वकालतनामा क्यों नहीं आता?
वो लोग नहीं आए मेरे पास.
नहीं है, ठीक है. And he undertakes to file the वकालतनामा within a period of 1 week from today. The appeal has abated as against
लिमिटेशन में नोटिस किया था,
लिमिटेशन
पॉइंट पे आईए पे नोटिस किया था.
आइए पे नोटिस डिले का नोट कर देते. कितना डिले है बताइए. How much is the delay? 40 days. 40 days delay का नोट कर.
40.
आइए नंबर 4559 of 2022.
Milord, with your permission, I would like to read out 4 lines of the first appellate court. But the observation of first appellate court is during
डिले
this
पहले का नोट कर देते हैं, है ना. 40 days delay in filing the second appeal is hereby condoned. इनका appearance record करें. Disposed of है. आइए पेंडिंग नहीं है, आपको खुद ही नहीं पता. हाँ बताइए क्या आप बोलना चाह रहे हैं.
11 नंबर पॉइंट है मिलॉर्ड की.
सुनेंगे ना, आपको सुनेंगे, सुनेंगे, ठीक है. इनको प्रोफॉर्मा को नोटिस करने का जरूरत है कि आप खुद ही अपीयर होंगे. डिफेंडेंट्स जो बाकी जो हैं, डिफेंड नंबर 2 and 3,
तो नोटिस जाता है.
आपके पास इंस्ट्रक्शन नहीं है उनकी तरफ से. The respondent number 1, no notice need be issued to respondent number 1. Let notice be issued to respondent number 2 and 3. Through the concerned police station. The notice should be accompanied with a copy of the memo of appeal and also its enclosures. The requisite be filed by Monday. आप फाइल कर देंगे मंडे तक. Let the records be called for from the concerned court. ठीक है. Post this case under the heading for final disposal on March 4th in the supplementary list. जितना मांगे थे उसके बियॉन्ड तो नहीं मिल सकता ना. इतना ही भरा है बस. शुरू में हमारा नजर नहीं पड़ा है, बाद में in the midst of the dictation he pointed it out.
अपीलेट कोर्ट का फाइंडिंग
जितना मांगे थे उससे बियॉन्ड नहीं मिल सकता. तो सेलवीट का डिक्लेरेशन मांगे थे उतना ही भर मिलेगा, उसके बियॉन्ड नहीं मिल सकता.
Item 5, second appeal 81 of 2020.
Yes. ठीक, पास हो. डेट नहीं होगा, पास ओवर खाली होगा. नहीं तो आप पढ़ लीजिए, तैयार है.
Item 6, second appeal 104 of 2020.
Yes, Apina.
This is concurrent finding, Lordship.
Yes.
And fact of this case, Lordship, that in the year 1919, that is Gosai Khargaridhar.
Let us see what are the questions of law you have
Yes,
formulated. Substantial questions.
ये लॉर्डशिप
पढ़िए कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ पर आप रिलाई करना है?
C
C.
C and D, yes लॉर्डशिप
C and D.
D.
Just a moment. Where are the discussions of these documents in the trial court? You argue your case. बताइए. You argue in your own manner, right?
Para 4 of
Yes, please.
okay, para 4 lordship of order of title appeal.
पहले ट्रायल कोर्ट से शुरू करें.
हाँ, yes lordship.
पैरा 4 पढ़िए आप ट्रायल कोर्ट. What was your case? You tell us in short. What was your case?
Yes. Lordship, my case is that, Lordship, the land was settled in the year 1919. The total rakba was 2.86 acre, and out of this, the Gosain Khargadhare, he executed the registered deed to Balia Kahari. That is Rati Patta number 673 dated 24 April 1999. And this Balia Kahari lordship sold the land out of 2.86 acre, 1.10 acre to Umia Kahari, void sale deed number 9128 in the year 1953 lordship. And this Umia Kahari lordship gifted the 82 1.8 decimal of that land to Jagdish Ram, void gift deed number 4252 lordship. And Jagdish Ram gifted this land to his daughter Fudo Devi lordship. And I purchased this land from Fudo Devi lordship, void registered sale deed number 2996 dated 16/5/2008 lordship. So lordship, my submission here is that lordship, that learned court disbelieved this registered patta and relied upon Sada Hukumnama lordship. And
You had purchased the property.
Yes.
From
Fudo Devi, appellate number 2.
Fudo Devi.
Yes.
Fudo Devi had got this property by virtue of
Gift deed.
gift deed.
Yes.
The gift deed was executed by
From her father Jagdish Ram.
Jagdish Ram, right?
Yes,
So
yes.
Jagdish Ram gave it to Fudo Devi.
Yes.
This is gift deed, right? And
Yes.
Fudo Devi sold it to you.
Yes, lordship.
You were the defendant.
Yes.
Registered sale deed.
Yes.
Right?
Yes.
And Jagdish Ram got it from whom?
From Umia Kahari lordship. Void registered sale deed.
Sale deed number?
Sale deed number 9128.
Dated?
1953. Dated 8/10
And
8/10/1953. Yes, lordship.
Umia Kaharin had title from whom?
From Balia Kahari.
And Balia Kaharin from whom?
From Gosain Khargidhar.
The land was recorded in whose name?
Gosain Khargidhar.
The
He
entire
was
story is that the basic sale deed is forged.
Yes. Yeah, Lordship.
This is the entire story.
Yes, Lordship.
So, if the basic sale deed is forged, then all the subsequent sale deeds are bound to fail.
But that is not forged, Lordship. The
What is the finding? What is the main issue framed by the learned trial court?
yes, main issue issue number 7, Lordship.
You also claimed adverse possession,
No, adverse possession, no, not Lordship.
barred by law of adverse possession.
Yes,
waiver
yes,
is-
I am in possession of that land, Lordship.
You claimed adverse possession.
Yes, Lordship. Yes.
This is issue number Roman 2. Correct?
Yes.
The possession has been found in whose favor?
In Prasadi Rana. Appellant.
Appellant.
Appellant. Appellant number 2.
No, possession
No.
was also declared in favor of the plaintiff and the pro forma defendants. Their possession, you were not even found in possession by the learned trial court. You see? The suit of the plaintiff is decreed on contest. It is hereby declared that the plaintiff and pro forma defendant number 3 to 6 have got valid right, title, interest and possession over the suit land. Even possession was decided against you. There is no question of reappreciation, right? You tell us that which document has been wrongly considered or perverse. Mere question of law is not sufficient. You have to frame a substantial question of law.
Lordship,
Yes?
main question here is, Lordship, that the order of revenue court, can it create title?
It is not creating any title. You were claiming by virtue of some sale deed, your sale deed was not found to be proper. Your claim on the basis of the sale deed was rejected. These are not questions, substantial questions of law, which whatever you have framed are not substantial questions of law.
Also, one more submission, Lordship, that document produced that is exhibit A, A1, A2, A3 and BB7, that has also not been considered, Lordship, because learned court relied on the jamidari receipt, rent receipt only, Lordship, and it did not rely on the original sale deed, Lordship.
No, original sale deed, you see, was held to be not proper because through zamindar it was flowing on the
Yes.
on the plaintiffs. So that was not sufficient. A person who is selling the property without having the title, that is of no use, isn't it? Likhi. हम लिखाएंगे इसको सेकंड, बट देयर इज नो सब्सटेंशियल क्वेश्चन ऑफ पॉइंट. इसको फाइल पूरा देख लें. ठीक है?
Seven, second April 130 of 2020.
madam.
Yeah, yes, Your Worship. This is reversal, Your Worship. Although the plaintiff, the suit was declared in their favor, subsequently the defendant filed the suit, appeal, then it was declared in favor of the defendant, and after this plaintiff, he has preferred the second appeal, Your Worship. Now, in this case, the suit of the plaintiff is, Your Worship, he has paid rupees.
Was the plaintiff examined?
No, plaintiff was not examined, Your Worship. He has given the special power of attorney to his
For
father.
cross-examination, the power of attorney holder can examine and cross-examine.
Your Lordship, in this case,
Is it permissible under law?
No, it's permissible because, Your Lordship, it's a
It requires some personal knowledge, readiness, willingness. These are the factors for suit for specific performance which are required to be established.
By that. Now,
Yes.
in this case,
how the power of attorney holder will be cross-examined on this point?
that is true, but Your Lordship,
Why did the plaintiff not appear?
he did not, plaintiff did not.
Initial
appeal
suit
that.
was not filed through the power of attorney
No,
holder.
it
It was filed by the plaintiff.
himself.
Plaintiff did not come to support his case.
No, plaintiff
He
did
gave
not
the
come-
power of attorney
but
to
Your
somebody
Lordship,
else.
The witnesses who were there, they were
That is not
the
sufficient.
agreement holder. They have supported the
No,
case.
that is not sufficient.
No, but as per Order 3, Rule 1 to me, the power is being given to the power of attorney.
Not for the purposes of
Mas-
witness, and
yes.
for witness, the person has to appear himself.
No, but if we just see the other way, Your Lordship,
How-
the amount which we have given, that has not been.
The amount, you see, the mere payment of amount, there are so many aspects in specific performance of contract. Merely by making payment of the amount is not sufficient.
No, that is not
There
Your
are
Lordship.
other
Now, they
ingredients
say
which are
we have
required to
not
be
executed.
satisfied.
The case of the defendant is we have not executed any agreement. Your Lordship. So they say, but we have already returned that amount. But
Yes.
that has not been proved as per their evidence itself.
See,
No documentary evidence has come forward, Your Lordship, to prove that
the
that has been
appellate
returned.
court has taken a view that the plaintiff himself did not come before the court to depose, and there was no occasion to examine or cross-examine the plaintiff.
Only on the point, Your Lordship, because that
Sufficient.
necessary, that point is ki whether the subsequent, but on affidavit in
So,
the plaint itself,
he was a
it is
subsequent
there,
purchaser?
if it-
The power of attorney was a subsequent purchaser?
No. Power of
When
attorney
was the
was
power of attorney executed? When was the power of attorney
after
executed?
filing of the suit.
After filing of the suit.
After
So,
filing of the suit. But in this case, Your Lordship, there
No,
is
no, no.
there is one thing, Your Lordship, because the
Nothing is
power, he says the amount has been returned to the father as per
whatever,
the
it
defendant's
makes no
statement.
difference, madam.
But
The
then,
power of attorney has been executed after the suit was filed, and the plaintiff did not take any interest in the suit. He did not appear, and the power of attorney holder is produced before the court for examination and cross-examination.
power of attorney, because he was, special power was given.
For
to
what?
contest
To
that
depose?
No, special
To
power
depose
was
before
given.
the court.
No, special power
No,
was given to
power can
contest,
be given
do
to contest,
everything.
to do everything, but,
Yes, yes.
but
I have
how
the
he
power
can
to-
be replaced, madam?
No,
So far as evidence is concerned, the plaintiff was required to be examined.
the only on the point, Your Lordship, whether the other part of the
It is immaterial. It is immaterial. Rest of the part is immaterial. The plaintiff did not appear before the court to support his own case, and there was no occasion to cross-examine the plaintiff on the various aspects of the requirement of specific
if we just
performance
go
of
through the power,
contract.
if we just go through
We
the
are
power.
not concerned with the power of
No,
attorney.
because power is
Madam,
that
you just
power.
tell us. You just tell us. How is it possible that instead of a particular witness, his power of attorney will come and depose on behalf of the witness? How is it possible?
Because that power is also
It
being
is not
given
possible
for
under law,
execution
ma'am.
of a decree, Your Lordship.
No,
Now,
no.
if the decree is being,
No.
that is, Your Lordship, that power is also being given. It's not the power only to
तब तो
contest
I was
or to
giving an
sign or
example.
verify.
Power of attorney पर फांसी का सजा भी हो जाना चाहिए.
It's
Why
not
not?
that. No, Your Lordship, it's not that. In this case, why, Your Lordship? Otherwise, the power under Order 1, Rule 1 to me, the power has been given, Your Lordship.
No,
Order 3,
you
Rule
see,
1
you
to
show me any
the-
law that the witness can be examined. The witness, the power of attorney can come and depose in place of witness. Show me any law,
In this case, the only
and particularly when it relates to
The,
personal knowledge.
personal knowledge regarding the agreement, Your Lordship. That is, otherwise power of attorney can come and
No,
depose,
no,
but-
no,
but
no,
so far
no,
the
no.
personal
I have
knowledge,
not come across
personal
any such
knowledge
thing.
is concerned, Your Lordship, that is the plaintiff evidence is the must, Your Worship. Just for the cross examination, whether he was ready to
There are so many things.
perform
You
the-
see,
yes,
not
that
only
is-
the passing of the consideration amount,
No,
but also
for the
for the
because-
execution,
for the execution of
necessary
the agreement,
steps.
because we have
And
stated that
the
we have
second notice was also not exhibited. Two notices were
Two
given.
notices were-
Second
one
notice
notice-
was not exhibited.
one notice was exhibited. the
Only
other
one
notice-
notice was
one
exhibited.
notice
The
was
second
exhibited.
notice was not exhibited.
So that is there in the
No.
document, Your Worship. One notice has been
Can
exhibited. But we have in the plain specifically written that
Whatever, no.
plaintiff was ready to
Plain-
execute his part, Your Worship. It's not the case
you see,
where the
that
plaintiff
case,
was not ready.
merely
and-
because something is mentioned in the plaint by itself is not an evidence.
No, but then
Plaint
special-
is not filed on affidavit, like in commercial courts, right?
It is filed on affidavit.
No, in the commercial courts the procedure is different. This
Yes,
is not a
and
matter
the-
arising out of commercial court.
No, it's not arising out of,
No,
but
but
then
that
also the
is-
affidavit is
If
there.
the affidavit of the plaintiff is there, he has to come for cross-examination, madam.
Yes.
He has to come and depose and support his plaint, and then otherwise तो वो writ petition होता है. Writ petition की तरह plaint written ये suit नहीं decide हो सकता, madam.
That
It can't be like
because that is only the personal knowledge whether he is ready to he's ready to abide by his conditions of the agreement, Your Worship, because some of the amount which he has to pay.
Even all the conditions are required to be satisfied. Specific performance of contract is a very technical law, and in order to get the deed executed in terms of whatever agreement, every aspect of the matter is required to be proved by the plaintiff, and on every aspect the defendant has got a right to cross-examine the plaintiff. A person who enters into picture at a subsequent stage through power of attorney cannot come and cannot replace the plaintiff under any circumstances, at least for the purposes of witness.
But if you just see, Your Worship, the Order 3, Rule 1 and 2, where the power is being
Like, you are referring to which act?
CPC, Your Worship, Order 3. Order 3, Rule 1.
Yes.
Order 3, Rule 1, Your Worship. Appearance, etc. may be in person by recognized agent or by pleader. Any appearance.
This is appearance, this is
Yes.
not evidence. Madam, appearance is something else.
No,
Somebody
you-
can come and appear, but can somebody come and depose?
But two may author recognized agent may and act on behalf of such parties.
Act means what? Not examination and cross-examination. We can't permit this.
Only that part is there कि whether he is ready to abide by the.
वो तो
if
पावर
that
ऑफ
part is-
अटॉर्नी देकर जो है ना वो पावर ऑफ अटॉर्नी का जो सेल होता है ना वही हो गया.
No, it's not that Your Worship. He has given the power to his father only because he was too young at that time. I think the dealings have been done by the father only. That is the only.
The father can depose. We don't bother about it. लिखिए. Second appeal number 130 of 2020. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the imputed judgment passed by the learned appellate court, first appellate court, is a judgment of reversal. She has submitted that the appellate court has primarily rested its judgment on the ground that the plaintiff never deposed before the court. As a witness. And instead, a power of attorney had appeared as witness before the court. She has referred to order 2, order 3,
Order
rule
3,
1,
order 3.
order 3, rule 1 of CPC to submit that instead of the plaintiff, his power of attorney would have deposed as witness, and therefore the impugned judgment of reversal calls for independence.
And second point is that the defendant, they themselves, although by the burden of proof is on me, on the plaintiff, Your Worship, to prove that this amount was given for the execution of the sale deed. But so far the defendant is concerned, their case was that they have returned the amount, and that amount has been returned through check as per the case of the defendant, Your Worship. And that also they could not prove that that amount was returned through check, because they say that 45,000 check has been given to the father of the plaintiff, R.K. Sinha.
The learned
So-
counsel for the appellant has also submitted that, though being the plaintiff in a case of specific performance of contract, it was for the plaintiff to plead and prove the case before the court, and the plaintiff had paid the entire consideration amount in connection with the property involved in the present case. It was the case of the defendant that
They have already
they had
as a loan amount and then
refunded the amount
45,000.
Refunded an amount of rupees 45,000
1,000 through check
through
and
check, but
balance
but
by cash.
they and the balance by cash, but the defendant did not prove this aspect of the matter.
And this defendant का himself evidence था कि he doesn't have any documentary proof that check was given. That was his specific
Not
evidence.
proved is sufficient.
Yes.
After hearing the learned counsel for the appellant and going through the impugned judgments, this court finds that the suit was filed by the plaintiff, namely Alok Bhushan, for specific performance of contract and execute registered sale deed and get a registered sale deed executed in his favor with respect to the property described in the schedule to the plaint. There was a prayer was also made for passing appropriate order directing the defendant to do all the acts necessary to put the plaintiff in full possession of the scheduled property. And further relief. Yes. It was the case of the plaintiff that the plaintiff was in need of a piece of land, and the defendant approached the plaintiff and offered to sell the suit property, and both the parties entered into an agreement of sale dated 25th day of April 2005, which was reduced into writing. And the entire consideration amount of rupees 53,622 was paid to the defendant on the very same date. As per the condition of agreement, sale deed was to be executed by the defendant within 4 months in favor of the plaintiff. It was further case of the plaintiff that he had already performed his part and was still ready and willing to get the sale deed in respect of the sold property. And it was upon the defendant to fulfill his part for executing and registering the sale deed in favor of the plaintiff. The plaintiff made several requests, but the defendant deferred the matter on one or the other pretext, and the plaintiff got lawyer's notice requesting the defendant to execute and register the sale deed in favor of the plaintiff. The breach of agreement to sale entered between the parties could not be compensated in terms of money, and the plaintiff was still ready and willing to perform all acts, deeds, and things that may be required for execution and registration of the sale deed in respect of the sold property as per the agreement dated 25/5/2005. The cause of action for the suit arose 4 months after the date of agreement, that is on 25/8/2005, and further cause of action arose after service of second notice arising out of breach of contract. The defendant on notice had appeared and opposed the suit. It was opposed to be against the provision of specific relief act and the limitation, and barred by limitation. It was asserted that the market value of the suit was more than rupees 53,622 and no amount was received by the defendant for any agreement. However, the defendant accepted the fact that he had received an amount of rupees 45,000 as loan and had put his signature on 2 stamped papers and 2 blank papers, and he had put signature upon the papers, but he returned the said amount by checks and partly in check and partly through cash. It was his further case that there was no agreement prepared between the parties and that the plaintiff had practiced fraud and had not come to the court with clean hands. It was asserted that plaintiff was not entitled to any relief. As many as 6 issues were framed by the learned trial court. Which are as follows. Para 4 of trial court. The plaintiff had examined 4 witnesses . But plaintiff himself did not appear as a witness. The 4 witnesses did not appear as a witness. The learned trial court considered the issue number 4 and 5 from paragraph 7 onwards, and after scrutinizing the materials, came to a finding in paragraph 13 that The agreement dated 24/5/2006 is a valid one and was subsisting, and the defendant was bound to execute and register the sale deed with respect to the suit line in favor of the plaintiff. The plaintiff had proved his readiness and willingness, and the two issues were decided in favor of the plaintiff. The learned court decided the point of limitation in favor of the plaintiff, other issues also in favor of the plaintiff, and on contest directed the defendant to execute and register the sale deed in respect of the scheduled land as per the terms and conditions of the sale. The defendant filed appeal, and the following issues were, the following points for determination was framed by the appellate court. Para 15 में while deciding the point of determination number 1, the learned appellate court recorded that both the parties, that is the original plaintiff and the defendant, were well known to each other and had good relations. And the point number 1, as to whether the holder of power of attorney can depose on behalf of the principal, was considered in paragraph 17 of the appellate court judgment. The learned court recorded that the PW3 Rajen Kumar Sinha who was the father of the plaintiff, had appeared and deposed before the court on the basis of power of attorney executed by the plaintiff. The learned court, the learned appellate court recorded following findings. Para page number 9, internal page 9 se, we'll just take it from here. Appellate court ka judgment. The learned court ultimately held that the power of attorney holder does not have personal knowledge of the matter of the plaintiff, and therefore the power of attorney could neither depose on his personal knowledge, nor could he be cross-examined on those facts which add to the personal knowledge of the principal, and held that the power of attorney holder had no power to depose in the matter. The learned court also recorded that when the agreement to sale dated 25/4/2005 was executed between the plaintiff and the defendant, where the father of the plaintiff, Rajen Kumar Sinha PW3, was not present, and also recorded that the attesting witnesses of the agreement to sale did not support the fact that at the time of executing the agreement, PW3 was present. While deciding the point of determination number 2, the learned appellate court has considered the materials on record and recorded that the plaintiff did not come forward before the court as plaintiff witness to prove the fact that he had put a signature upon the agreement dated 25/4/2005. The findings with regard to point of determination number 2 is as follows. With respect to determination of point number 3 and 4, the learned appellate court recorded the following findings. The appellate court also recorded that the handwriting of the plaintiff upon the agreement to sale dated 25/4/2005 and the handwriting in the power of attorney had no similarities. इस इशू का 2 जगह फाइंडिंग है. The learned appellate court considered that the decree passed by the learned trial court was not based on proper appreciation of law and appreciation of facts, and it could not be allowed to stand. The learned trial court had not considered the issue in the condition while the plaintiff did not come before the court as witness in the suit of specific performance of contract, while requirement of section 16(c) of the Specific Relief Act, and ultimately set aside the decree, judgment and decree passed by the learned trial court and allowed the appeal. This court has gone through the impugned judgments and is of the considered view that the learned appellate court has rightly taken the view that the power of attorney could not have deposed on behalf of the plaintiff who had initially filed the suit. Inasmuch as the plaintiff was required to be examined and cross-examined with respect to other aspects of the matter dealing with specific performance of contract. This court finds that the impugned judgment passed by the appellate court is a well-reasoned judgment considering every aspect of the matter. No question of law, rather much less any substantial question of law arise for consideration by this court under second appeal. Accordingly, this appeal is dismissed. I'll put in a few judgment on scope of second appeal.
Item 8, second appeal 132 of 2020.
This is against concurrent finding of both the courts. The suit was filed for declaration of right, title, interest as well as recovery of possession. The defendants are claiming their title through a registered deed of gift, and that was also challenged by the plaintiffs.
The suit was decreed?
Suit was decreed and appeal was dismissed.
So let us see the case of the plaintiff.
Yes. If I may briefly narrate the facts.
Yes.
Actually, the plaintiffs are claiming their title, they are claiming to be the legal heirs of the recorded tenant, and there is no dispute with respect to that. The defendants are claiming their title on the basis of a Razinama, which was executed by the ancestors of the plaintiff way back in 1966. So, from 1966.
Razinama is what? What is Razinama?
It was an unregistered document minor through which I was put to possession. So I'm not claiming my title through that document. All I'm saying is that from 1996, I came in possession of the suit land pursuant to execution of that unregistered document. My father came in possession of the suit land. And this fact has been, the court also came to a finding that I was in possession, and that finding there is no cross appeal with respect to that. So
unregistered document
yes,
by which you were put in possession.
Put to possession. The most important thing, Minus, is that the court came to a finding that I was in possession of the land for more than 12 years. So, so far as finding of fact with respect to my adverse possession is proved.
Did you claim adverse possession?
Yes. So I am claiming title on the basis of adverse possession, that is there in my pleadings as well.
You claimed title on basis of Razinama or adverse possession?
Adverse possession.
Both?
Adverse possession, only adverse.
Let us see your case before the trial court.
If I may invite the attention of this court to paragraph number 3.
Para 4. No, sorry. Para 3 of the trial court judgment?
Yes,
Yes, please.
After admitting the case, defendants appeared and filed their written statement stating therein that the suit is not maintainable, there is no valid cause of action, and the suit is barred by law of limitation. The suit is barred for non-joinder of legal heirs of the descendants of Lakhu Bauri. The property covered under Khata number 235 is a matter of record, the true and correct. The subject matter of suit land related to so and so, originally owned and possessed by Lakhu Bauri and others, and in course of records of right, the name of Lakhu Bauri, and they remained as absolute owner and exclusive possession thereof. Lachu Bauri, Linda Bauri, Suru Bauri, Badal Bauri, while as absolute owner and possession in respect of so and so, having given possession to Gopal Chandra Bhattacharya, father of the defendant, under Razina. So possession was transferred, not the title.
Yes.
Which was executed by Lakhu Bauri. Yes.
Continue, please.
Yes. And since the date of possession under the said Razinama, Gopal Chandra Bhattacharya remained possession of the same and constructed a Khapra Post house covered by boundary wall from all sides, and Gopal Chandra Bhattacharya remained possession of the entire land referred to above being the suit land, and Gopal Chandra Bhattacharya throughout exercised his acts of possession as rightful owner thereof to the knowledge of the plaintiff and his other co-sharer. Plaintiff had got residential house at any portion of the suit land, rather the answering defendant had got his residential house over the suit land, built by his beloved father sometime in the year 1966, and since then the answering defendant is residing in his house since the time of his father. Gopal Chandra Bhattacharya acquired lawful title of the suit land by living therein with his father and family peacefully and continuously without any disturbance from anyone to the knowledge of the plaintiff. So again, there is some claiming title on the basis of possession. In course of a revisional survey operation and inquiry as well as possession and found possession of the answering defendant having his residential house therein, but is inadvertently recorded in RS Khatian Anabad Dakhal is not true and correct, and as the defendant owned and possessed as true owner have perfected his right, title and interest. Plaintiff neither in having any title and possession over any part of the suit land right from 15/8/1966, as father of the defendant owned and possession the suit land 15/8/1966 till the demise, and on his death the defendant has inherited the interest of his father. The plaintiff, in order to save limitation, wrongly stated that they had no knowledge of the deed dated 11/1/1990 and alleged that the knowledge after notice in case number so and so. On the basis of gift deed, rent has been paid to the state. Plaintiffs have not brought the suit within time, far less no suit filed earlier within time provided in the law. Plaintiff is out of possession of the suit land and seek the recovery of possession, but it is surprising that plaintiff purposely does not disclose about their date of disposition. The defendant further stated that deed of gift solemnly executed and registered before the Deputy Sub-Registrar Dhanbad and will stand for all times to come unless the same is set aside by competent court with specific time. The plain are not true and correct, as the matter of fact the defendant never acted anything contrary to law over and above the acquired right, title, interest and possession of the suit property in the manner referred, and his possession have not been interfered at any point of time. There is no valid cause of action arose for the present suit.
Why was there an amendment?
There was some amendment in the plaint minus the pursuant to which an additional written statement was also made. And please the additional written statement.
No, not.
Now, if your lordship may kindly come to page number 10, running page 25.
No, what is the finding of the learned trial court?
Yes, minus that is.
Para number 12.
Regarding possession in RS,
You read para 11 also.
the counsel for the plaintiff submits that plaintiffs are belonging to scheduled caste and a person belonging to scheduled caste can transfer immovable property only to member of scheduled caste within district with prior permission from deputy collector under section 46(3) of the CMP Act. Defendant is not a member of scheduled caste, so that the suit land cannot be transferred in the name of defendant. He also referred several case laws in this regard, but cannot be considered at this stage because in this regard there is no issue and no pleading in this case. Regarding possession in RS Khatian shows that nature of land mentioned as Gora 2 and in remarks column shows that Gopal Chandra Bhattacharya is in Avayad Dakhal, illegal possession. The Razi Nama exhibit D shows that Gopal Chandra Bhattacharya, father of the defendant, was in possession of the suit land by constructing house more than 12 years before execution of Razi Nama dated 15/8/1966. TW1 and other defendant witness also stated that ancestor of defendant was possessing the suit land since long. TW1 stated his grandfather is in possession since 1950. It also appears that the nature of land mentioned Gora 2 does not mean that there is no house over the land. Learned counsel for the defendant submits that exhibit A, B and C is evident that defendant is in possession of a suit land. In this regard, he referred some case laws in support of this case. This is very important. Hence, I find and hold that the ancestor of defendant was in possession by constructing house more than 12 years before execution of Razi Nama in the year of 1966, and presently defendant is in possession and also paying rent to the government. Consequently, it cannot be said that defendant is not in possession of the suit. So I was in possession of the suit and even before the execution of Razi Nama.
Now further.
Yes. The learned counsel for the plaintiff submit that finding recorded in revenue proceeding are not binding on civil court and mutation proceeding is not a judicial proceeding. Mutation proceeding are administrative proceeding. He also referred case law in support of his case, so and so. In above referred cases, the Honorable High Court held that mutation proceeding is administrative proceeding and finding recorded in revenue proceeding not binding on civil court. Hence, mere open Jamabandi not confer any right, title and interest because mutation proceeding is an administrative proceeding for fixation of rent and issuance of rent receipt. The submission of counsel of the plaintiff can consider and appreciate. Considering the case of both sides in totality, I find and hold that plaintiffs are rightful owner of the suit land and they have valid right, title, interest over the suit property, but they are not in possession over the suit land. Further, I find and hold that Gopal Chandra Bhattacharya had not acquired any right, title, interest over the suit land. Therefore, he cannot transfer better rate from him to anyone, so that the alleged purported gift deed is nothing but merely a paper transaction created for the purpose of document of title. Hence, registered gift deed so and so is to be declared null and void and inoperative and also liable to be cancelled. Accordingly, both these issues, number 7 and 8, are decided in favor of the plaintiffs and against the defendants.
What about the appellate court?
Yes. The appellate court judgment will also may kindly come to paragraph number 19.
The plea of the point of adverse possession was specifically framed by the London High Court. Did they frame any issue on adverse possession? There is no issue on adverse possession.
So that is also a substantial question. There should have been an issue of adverse possession.
That is not the case. The court did not frame any issue on adverse possession. Then how can a finding be recorded on adverse possession? Not permissible.
That can be a substantial question. But otherwise, issue of limitation.
You see, when the parties have to join issues on that, no? And they have to lead evidence on that. Merely on the basis of materials on record, we cannot frame an issue over here which has not been issued by the court concerned.
But if there is a specific pleading malice, it is also the duty of the court to frame an issue.
Merely because there is a pleading, that is not sufficient. The issue in adverse possession requires lot of evidence. Then,
But
parties did not join
is
issues on adverse possession.
there is an issue of limitation malice.
Issue of limitation is different from the plea of adverse possession.
If I am in possession of the land for more than 12 years and the suit has been brought after 12 years, then it is also part under the Limitation Act, because otherwise the issue of adverse possession is covered under Article 65 of limitation. So this can be covered under Limitation Act as well. And if I have pleaded something categorically, it is also the duty of court to frame an issue. And there,
The court has not framed an issue.
so that can be a substantial question of law, is that there was required to be an issue on adverse possession. And considering the fact that the finding of fact with respect to adverse possession is in my favor, and despite that the
Finding of fact will not come unless there is an issue to that effect, isn't it?
and that but it has never been challenged, Mala. There should have, if the court has come to that finding,
They
there
need
should have
not,
been a
because
problem.
that is not the issue before the court.
The court should have come to a, but that is the sole issue, Mala, because I am not claiming my title through document. If I am claiming my title through possession, there should have been an issue on that.
There is a document you are relying upon which was subsequently executed in the year 1996.
No, it's
1966.
1966. So I am saying that I was put to possession by virtue of that document.
No, the finding is that you were in possession much prior to that document.
Yes, but you may kindly see my pleadings.
No, this is what the finding is that we have read, that the
Yes.
defendants have stated that you were in possession of the property since 1950.
So 1966 documents minus if I am claiming my title through that 1966 documents, then my plea of adverse possession becomes inconsistent. But nowhere in my written statement or pleading I am claiming my title through that document. All I am saying is that that was executed but I was already in possession, or I was put to possession by virtue of that document. I am not saying that I acquired title by virtue of that document. And apart from everything, my love, there is a clear-cut finding that I have been in possession of the property. In the judgment that I had given yesterday, my love, if you Lordship may kindly take a look at that.
We'll come to the judgment later.
Only on the ground that an unregistered document cannot transfer title, the suit has been decreed. But I am not relying upon that unregistered document for transfer of title. So Lordship may kindly see paragraph 19 for me, the appellate court's judgment.
Where is the appellate court judgment? Let us see the point of determination of appellate.
It is at page number 30.
It starts at page number 30.
Point for determination at page 35.
30.
35.
Following issues were framed by the trial court.
नीचे points of
Point of
bottom of the page. Point number 1, whether the plaintiffs respondents have been able to prove their right title interest over the land described in Schedule A1 of the claim, whether the gift deed bearing number.
Even before the appellate court, no point regarding adverse possession as well.
Yes, that is why, my lords, I was trying to show paragraph number 19, running page 39. Learned counsel for the appellant defendant. Learned counsel for the appellant defendant argued that since father of the defendant is in possession of the suit land since 15/8/1966, he has acquired title over the suit land by adverse possession after lapse of 12 years. Since he acquired title by way of adverse possession, he executed the deed of gift in favor of his son, that is defendant, on 11/1/1990. After execution of gift deed, the land has been mutated in favor of the defendant, and rent receipt has also been issued in favor of the defendant. Thus, defendant has acquired valid title over the suit land. Learned court below has wrongly decreed the suit in favor of the plaintiff. The title of the plaintiff got relinquished after lapse of 12 years, and the father of defendant acquired title.
The defendant claims possession since 1966.
Yes.
No, that is not correct.
In my pleading.
No, but evidences are otherwise. This is the subsequent document.
The finding is that, that I was in possession of the land before that. But that is my case, that if at all there was a finding, it has to be challenged. And since it has not been challenged, that finding of fact has attained finality. And if that finding of fact is there, then my case for adverse possession stands.
You see, since there was no issue, there was just observations or maybe findings, but parties did not, no issue was framed in connection with adverse possession.
Not if something is pleaded specifically and issue is not framed,
yes,
that is also a substantial question. Because it is duty of the court to frame issues. If your lordship may kindly see order 14 for a moment.
Just a moment. You see, the question whether the father of the defendant acquired title by way of adverse possession can be declared by a competent civil court. Defendant never filed any suit for a declaration on the basis of adverse possession. This is what has been recorded by the learned appellate court.
So, my lord, I was not required to file a suit because there was a previously there was a proceeding under section 87 of Chota Nagpur Tenancy that was also allowed in my favor. And this is where, my lord, if your lordship may kindly see the Supreme Court judgment that I had given yesterday. Because adverse possession ground can be taken as a shield and a sword as well. I can also defend my title on the ground of adverse possession, even if a suit is not filed. That is the illegality that has been committed by the court.
Now, got the written statement? The written statement. There is no plea of adverse possession taken in your written statement.
It is there in the pleading files. I just placed the plea. I am claiming title on the basis of possession.
See, unless that is why there is no issue framed. The point is that if you take a plea of adverse possession, then only there is an issue framed to that effect. The learned trial court has not framed any issue on adverse possession. There are discussions, findings, Where is your plea in the written statement that you have perfected your title by way of adverse
It is
possession?
there. If you Lordship may kindly see paragraph 13 again.
Your specific case was that you were put in possession by virtue of that document.
Yes. Yes.
Right? It was not your case that you have perfected your title by way of adverse possession.
Your Lordship may kindly see paragraph 3 again.
These three. Yes.
Yes. I'll place the entire paragraph.
You read.
After admitting the case, defendants appeared and filed their written statement stating therein that the suit is not maintainable. There is no valid cause of action. Suit is barred by law of limitation. The suit is barred for non-joinder of legal heirs of descendants of Lakku Bauli. The property covered under Khata number 235 is matter of record, true and correct. The subject matter of suit land recorded to CS plot number, originally owned and possessed by Bhikkhu Bauri and others includes record of rights. The name of Bhikkhu Bauri and they remained as absolute owner and exclusive possession thereof. Lachu Baudi, Gulinda Baudi, Suru Baudi and Badal Baudi, while as absolute owner and in possession in respect of CS plot number so-and-so having given possession to Gopal Chandra Bhattacharya, father of the defendant under Razi Nama, which was executed by Lakku Bauri and others dated so-and-so. And since the date of possession under Razi Nama, Gopal Chandra Bhattacharya remained possession of the same and constructed a Kapra post house covered by boundary wall from all sides, and Gopal Chandra Bhattacharya remained possession the entire land referred to above being the suit land, and Gopal Chandra Bhattacharya throughout exercised his act of possession as a rightful owner thereof to the knowledge of the plaintiff and his other co-sharers. The plaintiffs have got residential house at any portion of the suit land. Rather, the answering defendant had got his residential house over the suit land built up by his beloved father sometime in the year 1966, and since then the answering defendant is residing in his house since the time of his father. Gopal Chandra Bhattacharya acquired lawful title of the suit land by living there and his father and family peacefully and continuously without any disturbance from anyone to the knowledge of the plaintiff. So there is a specific pleading that I acquired my title by living there.
So, in a case where parties join issue through their plaint and written statement on a plea of adverse possession, but no specific issue having been framed. So, how does it become a substantial question?
There would be two substantial questions over this case. Firstly, if the court came to a finding that I was in possession of the land for more than 12 years, the suit of the plaintiff could not have been decreed. And there's a direct judgment of the Honorable Supreme Court on this point.
And secondly?
Secondly, my lords, that if a specific plea with respect to possession of acquiring of title by way of possession of the property has been taken, there should have been an issue with respect to that. And that has not been done.
Non-framing of certain issue by itself would form a substantial issue. Do you have any judgment?
I don't have the right, but I can get it. Your Lordship may kindly see order 14.
Order 14?
Yes.
Yes.
Framing of issues. Issues arise when a material proposition of fact or law is affirmed by the one party and denied by the other. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Your Lordship may kindly come to surplus 5. At the first hearing of the suit, the court shall, after reading the plaint and the written statement, if any, and examination under Order 2, Rule 10, and after hearing the parties or their pleaders, ascertain upon that.
So there is a hearing at the stage of framing of issues also.
Yes.
So you have not raised this issue.
So that is what I am trying to show, Melas, the subsequent part of this.
Yes.
Upon what material propositions of fact or law the parties are at variance, and shall thereupon proceed to frame and record the issues on which right decision of the case appear to depend. So therefore, my lords, what I am trying to submit is the duties upon the court to frame an issue.
And no duties upon the pleader.
Is there, my lords, but it's also a duty upon the court.
It is also a duty.
Because the word used in order 14 is shall. The
So
court
you
shall
have
frame.
to
And there's a subsequent order 14 rule 2 which also says that the court shall pronounce judgment on all the issues.
Certainly. That issue on adverse possession was required to be framed before taking a decision on adverse possession. It has got many intricate facts involved, and it is not a pure question of law. Adverse possession is not a pure question of law.
But there's no dispute, my lords, with respect to the fact
Maybe
that,
we do not know what dispute could have crept in.
and even if a court has come to a finding illegally, but that order has that
No,
finding has never
on
been
the
challenged.
basis of some finding recorded in the impugned judgment, which on which no issue was framed, we cannot declare that you are entitled for adverse possession.
But that would be covered under whether, my lords, I am in, whether the plaintiff or the defendant is has right title, interest, and position of the suit. Because I am claiming my title on the basis of possession. If title is decided, then then the issue of possession is also required to be decided. And what is adverse possession, my lords, is that it bars the plaintiff from filing a suit after 12 years has lapsed. So it is also an issue of limitation.
It is not just 12 years. Not just lapse of 12 years. There are other intricate evidences required so far as it is not just mere 12 years.
So it is also an issue of limitation.
So please do not make a statement which does not suit your knowledge of law.
But it is also an issue of limitation.
Certainly, it is limitation is one of the point of 12 years. Elapse of 12 years is only just one of the point
There
in
are
adverse
other things
possession.
required to be considered.
There are other points also, and the issue having not been framed, you tell us that non-framing an issue which will itself be a substantial question of law.
Get a judgment.
देखे हैं ये?
Maybe post it tomorrow. Because we have got a second appeal admitted on this point as well.
Maybe.
Specific pleading and there was no issue framed.
When there is a participation of counsels at the time of framing of issue, then you cannot put the blame on the court.
The appellate court has also given finding with respect to adverse possession.
कोई फाइंडिंग दे नहीं सकते. आप
Because
अपना
my
अलग
list
से सूट फाइल कर दीजिए एडवर्स पोजीशन का. आपके पास तो रेमेडी बहुत सारा है.
नहीं,
You
but-
see, parties have not joined issues on adverse possession, right? So findings on adverse possession was not called for at all, nor such finding can be recorded in this proceeding. You can still file you have that judgment. You can still file a suit seeking adverse possession. The appellate court has stated that you have not filed a suit seeking adverse possession, whatever, rightly, wrongly, whatever. It can be a shield also. The law is well settled on that. But you have not raised it. You have not raised that. You have not joined issues on adverse possession.
So, but my submission is, if it would have been mandatory.
Judgment दिखाइए कि issue गलत frame होने पर substantial question of law बनेगा.
But एक submission मेरा ये है कि if it would have been mandatory to frame an issue on adverse possession if I was claiming title.
Mandatory means what? What were you doing as a counsel?
If I was taking two alternative pleas, then
We understand it fully, but give me a judgment which says that non-framing of issue on a particular point will give rise to a substantial question. हमको नहीं लगता.
But if I am claiming my title on the basis of adverse possession only,
Fair enough.
and if
Fair
an issue has
enough
been
that
framed with respect to
an
title,
issue ought to have been framed in connection with adverse possession.
If-
There is
if-
no doubt
if-
on the face of the pleadings. But the courts having not framed an issue on adverse possession, right? So firstly, the appellate court could not have framed an issue on adverse possession, right? That issue could not have been framed by appellate court. And secondly, whether non-framing of an issue can itself be a substantial question. हमको तो नहीं लगता है कि ऐसा हो सकता है. दिखाइए.
So if there were two alternative pleas, तो फिर दोनों इशू बनाना जरूरी हो जाता है, like with respect to my title and with respect to my possession.
Yes.
But if I'm
We do not say that alternatively it could not be said. We ऐसा नहीं बोलेंगे. Because you were claiming on a basis of a saga document. It was not a registered deed or something. Maybe that you had executed a sale deed, a gift deed subsequently in the year 1990. But that is not sufficient. But
if I'm claiming my title only on the ground of possession, and an issue has been framed with respect to title, there need not be any issue with respect to adverse possession, because I'm claiming my title only on the ground of possession. If there were two alternative pleas,
you see,
so the
you
title
show
of,
me a judgment that non-framing of issue would itself be a substantial question of law, because substantial question of law is to be decided on the basis of materials brought on record. Now, an issue like adverse possession having not been framed, there is no material on record to decide the point of adverse possession. Therefore, I don't think that there can be a substantial question of law on the point of non-framing an issue. We can simply hold that this issue was not framed, not considered. You will have your, we need not even observe anything. You can still go for a declaration of declaration on the basis of adverse possession.
but decree has been passed for recovery of possession. That itself is illegal, because if court comes to a finding that even if the issue of adverse possession
And then a point, you see, and then I do not know whether any res judicata would apply or not. I cannot say, because res judicata might apply. You could have taken an alternative plea of, you have taken an alternative plea, but the court has not framed an issue to that effect.
But whereas the decree of recovery of possession is itself illegal, because even if adverse possession is not decided, let me take that assumption against myself. If the court comes to a finding that I was in possession of the land for more than 12 years, in this case more than 50 years, then the decree for recovery of possession could not have been granted, and that is a substantial question of law.
Mere length of possession will not entitle you for a declaration of adverse possession. There is much more to it, isn't it? So mere length of possession is not sufficient to claim a declaration of adverse possession.
Find a judgment.
खोजिए judgment खोजिए मिले. Heard the learned counsel for the appellant. The learned counsel for the appellant has submitted that the learned trial court has recorded a clear finding that the appellant was in possession of the property for more than 12 years. However, from the perusal of the judgment passed by the learned trial court, apparently no issue regarding adverse possession was framed. The learned counsel for the appellant submitted that he shall examine the matter further as to whether any substantial question of law can be framed on the point of non-framing of a particular issue by the learned trial court, even though the parties had pleaded their respective case. The defendant had pleaded his respective case in connection with adverse possession. Like tomorrow?
Tomorrow it can be given.
I'll also look for it.
Passport case item 5, second appeal 81 of 2020.
अब क्या पास हो पढ़िए कुछ नहीं आपके केस में इसलिए बार बार पास हो
No, your ladyship, he was here just for a case he went to court.
सिविल कोर्ट में जंपिंग नहीं चलेगा.
I understand.
You have to make yourself free from other courts. Or you prepare yourself.
Actually, I am a new track practitioner.
आपको इंस्ट्रक्शन नहीं है बहस करने का.
Second appeal is new for me.
न्यू इसमें न्यू क्या है? सबसे आसान तो यही है.
And I cannot get enough time to go through the entire judgment.
तो पढ़िए ना. कॉन्करेंट फाइंडिंग है. लंच में पढ़िए. सेकेंड हाफ में सुनिए. एडजर्न नहीं होगा आज ये केस. आपके कॉम्पिटेंस पर आपके सीनियर को कॉन्फिडेंस नहीं है. ये तो बहुत गलत बात.
He is prepared.
He is prepared. You also prepared. हमारे यहाँ के टाइम के लिए मत खड़ा होइए. If you are, you just tell him, tell your senior that if you have to appear before this court, you should be permitted to read the fine, at least.
From daily list of final dismissal item 1, WPS 5332 of 2010.
WPS number 5332 of 2010. Nobody appears on behalf of the petitioner. On 22/11/2024, also nobody had appeared on behalf of the petitioner. क्या मैटर है?
But if withholding of 25% of pension that the petitioner is challenging.
क्यों नहीं appear हो रहे हैं petitioner?
Leadership from the last 4 to 5 days the petitioner is not appearing.
Since the petitioner has remained absent repeatedly, this petition is dismissed for non-proceeding.
Applies petitioner.
Item 2, WPS 5374 of 2010.
इसमें भी petitioner नहीं appear हो रहे. WPS number 5374 of 2010. Same order. क्यों नहीं appear होते हैं? What's wrong with the petitioner? चलिए see. Dismiss for non-prosecution.
Item 3, first appeal 73 of 2023.
Yes.
case by I did some judgment is required only not to take real option. As I used to do, point for this, there was an agreement for specific performance of contract. There was an
ये
agreement
नॉट
between
टुडे
both.
के साथ क्या ही पूछ रहे हैं, क्या चाहिए आप?
वो not to इसलिए चाह रहे थे that some judgment is required because of the reason that the agreement which is in question.
By way of last chance आपका हो चुका है ना?
हो चुका बस एक दिखा not today.
कोई बात नहीं, आप थोड़ा पढ़िए.
पढ़ते हैं.
Specific performance of contract है?
Contract.
Who is for the respondent? You are there? It has been dismissed.
Yes. So according to the plaintiff, the case of the plaintiff, the on 10-5, the sale deed was executed. This is Sada sale deed. The Sada sale deed and Sada sale deed of agreement dated 10-5, notarized on 10-5-2011, but date has not been mentioned in the deed of the said sale deed, deed for agreement. And the sale is not valid under section 17B of the Registration Act 1998 because it is not registered, it is unregistered sale deed, although notarized. Date is not mentioned in the sale deed, exhibit 2 number.
तो आपका तो specific performance का दिया ही कहाँ है?
Amount जो mention किया गया है for that purpose में, therefore my lord I was
नहीं, amount mention किया गया मतलब specific performance का डिक्री कहाँ किया है? नहीं किया है. The defendants are directed to pay back rupees 55 lakhs. पैसा लिया था कि नहीं लिया?
पैसा नहीं लिया, इसीलिए
आपका कहाँ है written statement के पैसा नहीं लिया था?
मैं written statement में है, that is come along.
You see, the unregistered document can be used for collateral purposes, can't it be?
Unregistered my lord, that is violative under section 17.
इसीलिए तो आपका specific performance नहीं होगा. लेकिन for collateral purpose of refunding the amount,
the
you have
amount
taken.
वाले agreement को देखा जाए, वहाँ पर सिर्फ इन्हीं का अपना initial है, plaintiff का, defendant का initial है ही नहीं, और सिर्फ 6 और 25 ये जो date दे रहे हैं, only 25/6/2011 वो एग्रीमेंट के बैक साइड में ही लिखा हुआ है.
पैसा आप लिए हैं कि नहीं लिए?
हम लिए ही नहीं थे, हम लिए हैं सिर्फ 19,09,000 रुपया लिए थे और लिए हैं 25/11 तक. देयर आफ्टर नथिंग हैज बीन पेड. एग्रीमेंट को देख लिया जाता है.
तो आपका कहना ये है कि डिक्री 19 लाख का होना चाहिए?
19 लाख का होना चाहिए था.
यही आपका कहना?
यही मेरा कहना था.
रिटन स्टेटमेंट दिखा.
एग्रीमेंट में बहुत सारे का इनिशियल होना चाहिए.
रिटन स्टेटमेंट दिखाइए. पढ़िए अपना रिटन स्टेटमेंट.
जजमेंट में ही आया हुआ पेज नंबर 21 में है पारा 3. In the written statement to the user, preliminary objection that the suit was found frivolous vexatious as the suit is not at all maintainable either on the point of facts or law, that the suit cannot proceed in its present form. The suit is barred under the provisions of Transfer of Property Act, Contract Act, and also barred by invitation. That the suit is also barred under the specific reason that the suit is executed by the principles of this property. The statement contained in para 1 of the plaint correct sentence. The statement in para 2 of the plaint, the defendants have stated that it is being admitted by the defendant in method of record. The contents mentioned in para 2 of the plaint answering defendants have to submit that it is admitted by them. It is further submitted that the statements made by plaintiffs in the plaint in paragraph number 3 are hereby admitted, which is matter of record regarding genealogical table
by the defendant. And regarding part 4, as mentioned by the plaintiffs in the defendant strictly denied the same. It is only admitted a defendant's agreement for sale made by the defendant's verbal on 31/1/2011 and written on 25/6/2011, not on 10/5/2011. वो नेटराइज कर लिए एग्रीमेंट को देखने से क्लियर हो जाएगा, उसमें कोई एग्रीमेंट में डेट दिया हुआ नहीं था, सिर्फ
एग्रीमेंट तो एडमिटेड है ना, आप जरा देखिए आपका रिटन स्टेटमेंट में
एग्रीमेंटेड है,
एग्रीमेंट एडमिटेड है एज पर योर रिटन स्टेटमेंट।
वो रिटन स्टेटमेंट में
एग्रीमेंट के पीछे आप लिखे हैं कि 19 लाख रुपए मिला,
वो बस वहाँ तक है।
हाँ तो
वो तो कह रहे हैं कि नहीं उसके साथ में
एग्रीमेंट, द डॉक्यूमेंट इज एन एडमिटेड डॉक्यूमेंट ऑन रिकॉर्ड। व्हाट डू यू से?
वहाँ तक एडमिटेड, ओनली टू दैट एक्सटेंट,
ओनली टू दैट एक्सटेंट का क्या
एक्सटेंट
मतलब?
25/6 तक ही।
उसके पीछे आप लिखे हैं 19 लाख रुपए मिला है उतना
वो बात
बस
सही है, वो तो हम एक्सेप्ट
और बाकी क्या?
बाकी का वो जो कह रहे हैं कि नहीं 36 लाख
हाँ 36 कितना पेमेंट हुआ ये डिस्प्यूटेड है, लेकिन एग्रीमेंट तो एडमिटेड है ना, कंटेंट्स ऑफ द एग्रीमेंट की कितना पेमेंट हुआ ये डिस्प्यूटेड, ठीक है ना? तो ये आप ये मत बोलिए इनिशियल था और ये था,
नहीं इसलिए नहीं बोल रहे हैं कि वो जहाँ पर अपना कह रहे हैं कि हमने एग्रीमेंट दिया 36 लाख, वो वाला में सिर्फ अपना सिग्नेचर कर दिया है, ये किसी का सिग्नेचर उस जगह पर नहीं है एग्रीमेंट में, इसीलिए एग्रीमेंट इटसेल्फ वेग हो जा रहा है। ये बाद में कुछ
अरे डिग्री कहाँ किया है,
उसमें हम लोग आगे आ रहे हैं, इसमें हम लोग
स्पेसिफिक परफॉर्मेंस का डिग्री नहीं किया,
ठीक है, लेकिन जो
आपको बोला है कि जो अमाउंट मिला है वो आप वापस कर दीजिए।
तो हमको मिला जो है वो तो देने को तैयार है, लेकिन वो जो नहीं मिला उसको भी डिमांड कर रहे हैं, वो अपने से भर करके।
आप बताइए पेमेंट का क्या?
Exhibit 2 is the agreement document. In the body of the agreement itself, the amount of please sir interfere not. In the body of the agreement itself, the amount of advance of 36 lakhs has been written, and that is and that page also bears all the signatures of all the defendants in that page. In the body itself, the 36 lakhs has been mentioned, and thereafter 19,90,000 was given, which was endorsed in the back of the agreement.
हमसे भी पूछ लिया जाएगा,
नहीं हम पूछेंगे, आप तो आप टाइम मांग रहे हैं, थोड़ा समझने दीजिए क्या।
Yes.
Let me just understand what is the point of dispute between the parties.
In the body of the agreement itself.
Where is the agreement?
That is Exhibit 2, my lords. The second page.
सबका तो साइन है, कौन बच गया इसमें?
साइन वहाँ पर ऊपर में करा लिए हैं, लेकिन जहाँ पर 36 लाख लिखे हैं
वहाँ पे हर एक वर्ड के पास अलग अलग साइन होगा क्या? आपका कहाँ प्ली है कि एग्रीमेंट वाज फोर्ज्ड एंड फैब्रिकेटेड?
रिटन स्टेटमेंट में स्टार्ट से ही हम लिखे रहते हैं इसका
एग्रीमेंट इज फोर्ज्ड एंड
पैराग्राफ में ये सब पेज में ब्लैंक रखा गया था, और ब्लैंक रखा गया था उसको भर दिया, इसीलिए हम लॉजिक और नॉट टुडे वाली कर देते हैं।
नॉट टुडे मतलब टुमारो ही होता है यहाँ पर।
हाँ तो ठीक है, उसके लिए हमको कोई ये नहीं, लेकिन नॉट टुडे कर देने से थोड़ा हम इसको एक दिन में या डे आफ्टर कर दिया जाए।
ना अमाउंट इन्वॉल्व है।
हाँ बहुत ज़्यादा, इसीलिए थोड़ा सा टाइम चाह रहे थे क्लियर करने।
वही थोड़ा सा मतलब
90,000 तो कोई डिस्प्यूट नहीं कर रहे हैं।
नहीं 90 उसमें तो हम नहीं कर रहे हैं।
और जो बॉडी में लिखा हो उसको डिस्प्यूट कर जबकि एग्रीमेंट एडमिट करते हैं।
वो उन्हीं का सिर्फ इनिशियल अपना इनिशियल, और वहाँ पर साइड में इनका भी इनिशियल होना चाहिए था।
You should not have signed the documents if it was a blank agreement then. In the entire agreement, they are disputing three things, my lords: the date of execution of the agreement, the amount, and the consideration amount, advance amount and the consideration amount, and nothing else.
उसके बाद नोटराइज्ड हुआ है 10/5 को, वो लिखा हुआ है नोटराइज कर दो कि 10/5/2011 को नोटराइज हुआ, 30 को इतना तारीख को हम लोग बना रहे हैं एग्रीमेंट, ये नहीं लिखा हुआ है।
Because it was not a registered agreement, it was only a mutual.
तभी डेट होना चाहिए।
डिपेंडेंट कौन है? महेश गोप।
Yes.
महेश को
महेंद्र को
महेंद्र गोप और नहीं
महेंद्र को।
Who is महेश को?
He is one of the witness, my lords.
Hence, the dependent number 1. या तो पॉइंट ऑफ आर्गुमेंट को फाइल कर देते हैं लॉर्डशिप साहब
क्या
तो
फाइल
वहाँ क्लियर
करते
कर देंगे इसमें थोड़ा
But Mahesh
amount
Gop
ज़्यादा
the notice was issued, legal notice was given, that is Exhibit 3. In that, the signature of Mahesh Gop is there.
नहीं, इसमें भी है गवाह.
हाँ.
Mahesh Gop is one of the witness to the
Yes,
agreement.
yes. इसमें भी है.
Mahesh Gop has been examined? Must
Yes,
have been examined as a witness.
Yes, he was examined. He was examined as he was examined. I'm just giving there's a chart, lots that PW5. PW5 है. Paragraph 4 in exemption chief, he says that यह कि उक्त इकरारनामा दिनांक 10/5/11 मेरे समक्ष बनाते से पढ़कर सही प्रतिवादियों ने इकरारनामा के प्रत्येक पेज पर मेरे समक्ष हस्ताक्षर किए थे. And he was a witness. Para 31 of cross exemptions, he again confirmed the fact that the defendants have given 36 lakhs on the day when the agreement was executed.
The difference of the statements of the witnesses, madam. वो कह रहे कि नहीं 25/11 को सिर्फ 19,25,000।
महेश गोप ने भी सपोर्ट किया है कि 36
अजय
लाख
कुमार
रुपए
गोप
दिए।
अरुण कुमार गोप कह रहे हैं पैराग्राफ नंबर 66 में कि दिनांक 25/11 तक महेंद्र सिंह यहाँ पर PW अरुण कुमार गोप का कहना है PW अरुण कुमार गोप पारा 66 में कह रहे हैं लॉर्डशिप क्या ऐसी और भी विटनेसेस क्या था, इसीलिए लॉर्डशिप थोड़ा इसको एग्जामिन करके ही मंडे को या कल टुमारो रख दिया जाता है इसको फिर देख करके।
आप यू हैव बीन एग्जामिन्ड एज PW DW
4 महेंद्र सिंह
महेंद्र गोप प्लेंटिफ है 4
नहीं इनका
और
डिपेंडेंट
महेंद्र सिंह है DW 4।
महेंद्र सिंह इज DW
4।
You are agreed by the direction to refund the money, right? And you are the plaintiff.
I'm the defendant.
Okay, defendant has been asked to refund the money.
Refund.
Defendant has been examined as DW
4।
4. Defendant is ना क्या नाम है?
नाम है महेंद्र सिंह।
महेंद्र सिंह। कब करिएगा बताइए।
नॉट टुडे कर दें मंडे को पूरा एविडेंस को क्लियर कर पॉइंट ऑफ आर्गुमेंट और जजमेंट वीडियो लाना होगा
वेडनेसडे को कर, ठीक है? इज दैट ओके? Learned counsel for the parties are present. The hearing of this case has commenced. The learned counsel for the appellant has submitted that the appellant is the defendant in the suit. Although the suit has been decreed in favor of the plaintiff and against the defendants for specific performance of contract dated 10/5/2011, directing the defendants to execute and register the sale deed in the name of the plaintiff. नहीं, ये तो नहीं है।
Executing of the sale deed नहीं है।
नहीं, execution of sale deed नहीं। Just a minute.
Only to refund the.
एक second. The learned counsel for the appellant has submitted that the suit has been dismissed on contest against the defendants, and the defendants are, however, being directed to pay back rupees 55,90,000, which they have said to have received as advance in connection with the agreement of sale. The learned counsel for the appellant has submitted that the receipt of rupees 19,90,000 only is the admitted amount. Post this case for further hearing on Wednesday.
Day after tomorrow. On next Wednesday, day after tomorrow.
Next Wednesday पढ़ना पड़ेगा।
15.
आप लोग भी पढ़िए, इतना इन्वॉल्वमेंट है, आप पढ़ लीजिए इस पर।
नहीं है। हाँ Wednesday हम तो day after tomorrow.
रिकॉर्ड है ना आप लोग के पास?
नहीं हम वो बात नहीं बोल रहे। Wednesday or day after tomorrow clear.
एक बार थोड़ा सा देख लेने से ना फिर हमको भी पढ़ने
Yes.
में सुविधा होती है
Yes, yes.
कि कहाँ आप लोग का झगड़ा चल रहा
No issue,
है।
no.
ऐसे पूरा रिकॉर्ड पढ़ते पढ़ते तो
खाली पैसा का ही झगड़ा चल रहा है, उसमें भी 36 लाख 19 लाख 90 हजार तो एडमिट कर रहे हैं।
30 लाख कैश निकाल के दे दिए थे। कौन से बैंक से दिए थे ये भी नहीं बताएं, सोर्स भी नहीं बताएं, खाली एग्रीमेंट में लिखा हुआ 36 लाख रुपए दे दिए थे।
डॉक्यूमेंट्री और जो लिखा हुआ बस वही डिबेट करेंगे।
वही ना, वही थोड़ा देखना पड़ेगा ना आपका क्या स्टैंड है और इनका क्या स्टैंड है। आपके घर में रखा रहता है 36 लाख रुपये। चलिए हो गया।
Serial number 9, which you have some difficulty today to know.
9 में क्या है?
इसमें एक IA है for additional evidence, on which judicial order is there for the other side to reply. That reply hasn't come.
No, no, we have filed the reply. To the IA.
It's not been served upon.
No, no, it has been served. How can it be filed without?
चलिए आज इनको तकलीफ है, कल दे देते। आपको मिला कॉपी?
कल नहीं।
क्या आपको अब तक कॉपी नहीं दिया है? ऐसा तो नहीं हो सकता है।
It is impossible.
इट इज इम्पॉसिबल, फाइल ही नहीं हो सकता है। आपका ऑफिस ठीक से नहीं चल रहा।
डेली फाइल में 2 वीक्स का टाइम उसमें रिमूव कर डेली फाइल 161 of 2020
In any case, your
2
addition.
weeks
ठीक है, जस्ट
removal of the decree.
सीरियल नंबर 5 में काउंसिल फॉर द अपीलेंट phrase for and is allowed time till 27th of January 25 to remove the surviving defects, post on 29th.
Already item number 6 has been removed.
वो हम नहीं जानते, वो आप देखिए,
Office set to change.
वो आपका ऑफिस स्टेटमेंट। और कोई बात
Serial
In addition,
Just
इसमें
one more
in any
thing I
case.
want to point.
देखिए उनका काफी स्टेक्स है, बताइए क्या पॉइंट आउट करना।
उसमें ना appellate number 4 जो इनका है भगीरथ सिंह, not he has died. It has this information was given in the court below and substitution is yet to be made there.
कौन सा?
ये मेरा सीरियल नंबर विभास हो रहा है।
जो बहस हो रहा था वहाँ पे तो कोर्ट बिलो में दिया गया था इंफॉर्मेशन।
अभी मरे हैं in September 24 the respondent number appellant number 4 भगीरथ सिंह।
आप अपीयर कर रहे हैं उनकी तरफ से? नहीं, ये तो अपीलेंट नंबर 4।
Yes, appellant
आपको नहीं पता?
ये हमको अभी कल रात को बोले थे, हम इसमें नोट किए, इसीलिए वहाँ पे भी सब्स्टिट्यूशन बाकी है।
लोअर कोर्ट पे क्या एग्जीक्यूशन में होगा सब्स्टिट्यूशन?
एग्जीक्यूशन
पहले वहाँ होगा तब यहाँ होगा।
और ऐसे भी अभी डेड आदमी है तो ऑर्डर नहीं हो सकता, पहले तो करना ही पड़ेगा यहाँ पे।
यहाँ की वहाँ
दोनों जगह पे ना।
पहले वहाँ कर रखी आई, एग्जीक्यूशन में है।
हाँ, ये हमको कल रात को बताया गया था। हम
तो
नोट
कल
किए।
रात को झूठ मूठ कर क्यों हम लोग को फाइल
नोट्स
खुलवाते
हमको
हैं?
ये हम
मतलब क्या है इतना लेजरली क्या है आप लोग के लाइफ में?
इसमें नोट किए थे नोट्स हम, लेकिन नोट्स भुगतान नहीं किया।
इतना लेजर है, आधा घंटे सुन लिए आप बोलते हैं कि मर गया।
लेकिन हमको ये हम नोट किए नोट्स, हम सोचे बता देंगे, लेकिन हम चूंकि दूसरे कोर्ट पे तो हम दौड़ते हैं तो हम थोड़ा सा
दौड़ते सिविल का कोर्ट में नहीं आया जाता है,
इसीलिए हम बस
10 मिनट पहले आया जाता है।
नहीं, हम थे जो यहाँ पे आके भी गए
दौड़ते आइएगा तो ऐसा स्लिप करिएगा कि डिग्री हो जाएगा जितना का अमाउंट है उतना का।
ये एकदम आई एम एक्सट्रीमली सॉरी फॉर दिस।
इसमें और लिखिए कौन सा है बताइए। आइटम 3 फिर से लिखिए। द लर्नेड काउंसिल फॉर द रेस्पोंडेंट, पूरा काट दीजिए ऑर्डर। द लर्नेड काउंसिल फॉर द रेस्पोंडेंट हैज सबमिटेड दैट द अपीलेंट नंबर 4 हैज एक्सपायर्ड
यस
and this fact has been
ये appellant number 5 है यहाँ पे।
appellant number 5 namely
Bhagirath Singh
namely Bhagirath Singh has expired.
Yes,
and this information has been given in the executing court. Counsel for the appellant has submitted that he shall take necessary steps in the executing court as well as before this court. However, he submits that first the substitution be made before the executing court and the order of the executing court will be brought on record before this court. ठीक है? For substitution.
यहाँ भी साइन करना पड़ेगा।
कर दीजिए आप, जो करना आप कर दीजिए, ठीक है? Just a moment. Post on date पता है कौन सा डाल दें?
डेट अपना कन्वीनियंस से।
मेरा कन्वीनियंस तो हमारे ही नहीं डेट, मेरा कन्वीनियंस 25 फरवरी करा के लेके आइए वहाँ से।
सीरियल नंबर 4 ऑर्डर्स में मुझे डिफेक्ट के साथ
हाँ, क्या करना है?
वो जो
50,000 could be there, only 5 perimeter 4 weeks for the first time आया.
ठीक है, सीरियल नंबर 4 में लिखिए.
FA first appeal.
आइए एक्सेप्ट कर लेते हैं.
आइए में तो लिमिटेशन पॉइंट.
नहीं, आइए में तो वो है एक्सेप्टेंस ऑफ वकालतनामा.
अब उनका था.
हाँ.
अदर साइड.
Serial number 4. FA number 159 of 2024. File.
49,070 is the deficit code.
IA number 13333 of 2024 in FA number 159 of 2024, which has been filed seeking acceptance of wakalatnama on behalf of the respondents is allowed. Counsel for the appellant prays for 4 weeks' time to remove the surviving defects. Post on 25th of February.
25th of
February. और बताइए
लीडरशिप इसमें आज
7 में
आज दे दे रहे हैं.
हाँ दे दीजिए.
आइटम नंबर 7 में लिमिटेशन के लिए हुजूर प्रीम्प्टिव चार्ज 4 सप्ताह.
Item 7, 6 and 7 wrongly listed.
6 and 7 wrongly listed है, छोड़ दीजिए.
Wrongly listed है.
Wrongly listed. आइटम नंबर 5 तो हो गया, ठीक है. और बताइए कौन सा?
हमारा 9.
सॉरी.
आइटम नंबर 9 था.
9.
इसमें इनका जो रिप्लाई एफिडेविट इन रिप्लाईज
हाँ.
भी मेरे पास somehow नहीं था. नॉट स्पीकिंग.
At the request of the counsel for the appellant, pose this case on next Tuesday. Okay, sir.